Hello and welcome to today's webinar on regulatory and IP strategies in the time of COVID-19. Thank you for joining us. I'm Toby Thompson and I'll be hosting the webinar, which is brought to you by FB Rice in conjunction with Hydrix. So a brief word about the organisations before we get started. Hydrix is a product design and engineering company specialising in complex, regulated and safety critical projects in technology areas including medtech and medical devices. FB Rice is a leading independent IP firm providing support and advice to clients regarding intellectual property and covering patents, trademarks and designs. Now, before we get started, I'd just like to mention a couple of items. So everyone joining the webinar today is muted, but we do welcome questions. So please do send those in via the Q&A function and we'll address those at the end of the main presentation. We're also recording today's webinar and we'll circulate a link that will be made available after the presentation. So turning to our speakers today. Today we have Michelle Knight, who's a clinical and regulatory manager with Hydrix. Welcome, Michelle.
Thanks, Toby.
And joining Michelle is Madeline Kelly, a patent attorney and partner with FB Rice. So hi, Madeline.
Hi, Toby.
Okay, Michelle, perhaps I could start by turning to you and asking a question. So at the moment, there's this rush to get products such as the PPE, ventilators and masks and the like on the market. For companies that are developing these products to address the COVID-19 pandemic, are these still subject to regulation?
Yeah, thanks, Toby. There is the rush to be able to produce these products and supply them, not only in Australia but globally, but you still do need to consider the relevant regulations that apply. And regulators are doing everything that they can to make this process as transparent and expedited as possible. So regulators are receiving a number of calls and inquiries from manufacturers who are keen to produce products, and they're using novel technologies and advanced manufacturing pathways. And 3D printing is a good example of this. To assist in this process, the regulators have provided expedited pathways for personal protective equipment and ventilators and other medical devices to combat and treat patients with COVID-19. In Australia, the pathway is an emergency exemption, and that applies for medical devices in general in the context of COVID-19, but also specifically for PPE and other articles, ventilators and accredited laboratories. In the US, there's a similar process and it's called the Emergency Use Authorisation. And both of these processes enable these products to be used in healthcare facilities during the COVID-19 crisis. Regulators have provided clear definitions about what the products are to be considered under this exemption. And the TGA has also provided access to applicable standards that enable Australian manufacturers who are keen to participate and produce these products ready access to information in order to do so.
So how can Australian manufacturers assist in the response to COVID-19, Michelle?
Yes, so if you're an Australian manufacturer and you are keen to be able to produce these products, then you need to consider that you have appropriate certification to manufacture and supply products here in Australia. And that's compliance to ISO 13485. If you don't have this certification, then we suggest that you register your interest and your core competencies at the Advanced Manufacturing Growth Centre. They'll put you in contact with manufacturers who have this certification and enable these products to be produced.
And is COVID-19 triage or diagnosis software regulated?
Yes, so software also needs to be considered, and companies are keen to be able to develop software to assist in the tracing or tracking or treatment of patients with COVID-19. This software can be clinical decision support exempt if it enables the health professional to independently review the recommendation and to decide on their own treatment options rather than the software doing it for them. In particular, the software can't be intended by the producer to acquire, process, or analyse images from in vitro devices or from medical image acquisition systems. And all other medical devices, such as ventilators and blood purification systems, are regulated and can go through these expedited approval pathways.
Thanks very much, Michelle. Madeline, if I could turn to you and ask you about the IP side of things. So if you're a company in the medical device sort of healthcare sector and you're looking to sort of provide technology to address COVID-19, I mean, how do you manage your IP strategy, perhaps in a scenario where some companies might be sharing technology openly, for example?
So these are extraordinary times. Some of the greatest minds of our generation are directing their attention to finding solutions to diagnose and treat COVID-19. And with this hotbed of creativity, there will invariably be a great deal of medical device innovation. Now, under normal circumstances, in normal times, company strategy would tend to dictate that IP relating to such innovations be protected. But these aren't normal times, and in view of the great humanitarian crisis, there's a great deal, or there appears to be a great deal of pressure on companies to openly share these innovations. But I suppose the question is, can you have your cake and eat it too? Can companies make a meaningful contribution to the fight against COVID-19, but still retain control over their innovations? And this is exactly what having IP does. It gives a company control over the use of that technology. It gives a company choices. So the company can then decide whether they want to prevent others from using the technology and perhaps supply the market themselves, to assign those rights to somebody else, to grant licenses to third parties, or even to share the technology freely. Now, I think what people need to bear in mind is that the pandemic will end at some stage, and also that any innovations that may have been produced are likely to have uses beyond COVID-19.
Madeline, what mechanisms can companies use to control their IP beyond COVID-19?
So this is where licensing can be a great option, and I have actually an example of this, and it's a collaboration between University College London and Mercedes AMG high performance powertrains. So now what this team has done is developed a continuous positive airway pressure CPAP device. And it's an improvement over existing devices in that it optimizes oxygen consumption. Its contribution to the fight against COVID-19 is that it reduces reliance on ventilators, which then may be kept for use with only the severely ill. It's relatively simple to manufacture and it can be produced quickly. Now, what the team have done is they've decided to share the technical specifications for the device for humanitarian purposes. And they're doing this by way of a 2-year license to a design and manufacturing instructions package to a particular group of people. So in this way, the team is able to maintain control over who uses the technology, for what purpose, and for how long. And it also ensures quality over the manufacturer. And of course, anyone seeking to manufacture and use the technology must have regulatory approval in the relevant country.
Thanks, Madeline. So Michelle, if I can come back to you. You mentioned regulatory exemptions earlier. What about the situation where there's not an exemption available? Are there still ways to speed up the regulatory process for Australian companies? And also, I guess, are there any issues for Australian exporters who might be looking to supply equipment to other markets?
Yeah, so I've got a couple of examples to talk through in the Australian context. The first is for personal protective equipment, or PPE. So PPE, of course, we're talking about disposable face masks, gloves, gowns, protective eyewear and the like. As an Australian manufacturer, you need to first of all assess whether or not you intend to make a therapeutic claim on this product. If you don't, then it's considered to be a general consumable. It's non-sterile and it's apparel or equipment for use in the home, for occupational or recreational use. It's not considered to be a medical device and doesn't require registration on the Australian Register of Therapeutic Goods, or ARTG. For all other PPE, where there is a therapeutic claim attached, the first mechanism is via a government contract. If you're a manufacturer or a supplier with an Australian Government Department of Health contract, or acting on with an agency who does have a contract, then you're exempt from all the regulatory pathways within Australia, such as conformity assessment procedures and certification, and you don't need to register your device on the ARTG. If, however, you're a manufacturer in Australia or a supplier without a government contract, then I suggest that you submit an organisational details form to the TGA via the ebs@health.gov.au website. And this registers you as a TGA client and will enable you ultimately to list products on the ARTG. Again, as an Australian manufacturer, if you're certified to 13485, then you can apply to the TGA for an expedited device registration for PPE. However, you're not exempt from essential principles, conformity assessment procedures or certification, and you do need to register your product on the ARTG. As I mentioned earlier, if you're a manufacturer without ISO 13485 certification, then you should register your interest and core competencies with the Advanced Manufacturing Growth Centre. They can put you in touch with manufacturers who are certified. Through this expedited registration process, TGA then provides you with approval to supply your product to Australian healthcare facilities. The next example I'd like to talk you through is ventilators. If you're an Australian manufacturer, ventilators to be supplied in the Australian market must be manufactured here. They need to comply with minimal acceptable performance standards and have desired features intended for use in adults. They also need to be verified to the UK MHRA guidelines, and both of these documents are provided on the TGA website. As an Australian manufacturer for ventilators, you need to complete the following documentation to include with your submission. You need to complete a features and risk assessment checklist, test procedures and results template. You need to provide a declaration that the device has been manufactured in accordance with the minimal technical requirements, and complete an instruction for use checklist. As a ventilator manufacturer here in Australia, you also have obligations, and these are ongoing obligations for reporting, record keeping, and inspection and testing. You apply for expedited approval of an Australian manufactured ventilator through the TGA Device Conformity Assessment Section, DCAS. This expedited process then will enable TGI to provide approval to supply the ventilator to healthcare facilities during the COVID-19 pandemic. And to what you alluded to earlier, Toby, Australian manufacturers can export products into the US and EU markets But there are some restrictions that currently exist, and this is to prevent non-commercial export of PPE and disinfectant products. Commercial manufacturers can export PPE and disinfectant in addition to other medical devices such as ventilators and blood purification systems, provided that it's done as part of their regular business, if it's done through a humanitarian organisation, or if it is a non-commercial export, if it is a commercial export and that it's not done via Australia Post. And this is really to prevent panic buying or mass buying of PPE and disinfectant products in the Australian market for shipment overseas.
Great, thanks, Michelle. That's very helpful. Madeline, if I could perhaps come back to the IP side of things. I mean, does IP go out the window when people are developing technology for the public good? I mean, should it cease to matter?
I think it must be appreciated that it takes significant time and money to develop new technology. And really, investment is only going to be made where there's a reasonable likelihood or opportunity for an investor to obtain a decent return on their investment. Now, owning IP and having the right to control access to the technology provides a mechanism for recovering those investment costs. Having IP is usually one of the essential requirements in attracting investment to develop technology that might otherwise just sit on the shelf. So that remains the case even in today's climate.
Madeline, does owning IP give companies unlimited power over the use of that technology?
Owning IP does not give unlimited power over the use of technologies. Most countries have compulsory licensing and government use provisions, and those allow governments to use an invention where necessary or to authorize other companies to supply a patented product where demand can't be met. And that is without the say-so of the patentee. But in those situations, a reasonable royalty is normally payable to the patentee for the use of their invention.
Thanks, Madeline. If I could stay with you, could I just ask, what are the kind of commercial or public relations type of considerations that apply to sort of IP and IP strategy in the time of sort of pandemic as we are at the moment?
So I guess a key issue is going to be company image and public relations. While having IP allows control of access to a technology, how you use that power is going to be important. So in the present situation, being perceived as overly profiteering or perhaps obstructing access to essential treatment could have long-lasting negative consequences for a company's reputation. So a balance needs to be struck there. Another issue is freedom to operate. So for those looking to develop and launch new products rapidly, they need to be aware that there may be third parties out there who have patents which cover your new product. Now, normal rules governing infringements still apply. So unless governments have granted compulsory licenses, those other patent holders may be able to stop you launching your product. So it's important to do your due diligence and perform some freedom to operate analysis before investing significant amounts of money in the production development of new products and launch of new products, of course. So if you're considering doing that, you really need to be careful about freedom to operate.
Thanks, Madeline. And Michelle, if I could ask you, what role do ethical and privacy considerations have in this sort of desire to move quickly to release new technology?
Yeah, so there certainly are privacy and ethical considerations. Privacy, first of all, protection of data, personal data, comes under the general data protection regulations, and they recognise that in certain circumstances like these that we're facing with COVID-19, that personal and health-related data is to be processed when fundamental rights are at stake. And these rights are other than those rights relating to data protection by publicly by being able to share personal data and health-related data. It enables ready use of technology to assist in managing COVID-19. And of course, data controllers need to understand that there have to be organisational and technical measures in place which consider the context and scope and use of data.
Michelle, would COVID-19 justify the use of technologies or practices maybe which deviate from usual data security standards, maybe with the aim of facilitating speedy and safe response to emergency situations?
Yeah, absolutely. So to enable governments to respond very quickly to outbreaks of COVID-19 within the community, the Australian Government COVID Safe app is a great example of that. Using Bluetooth technology on your mobile device to look for other mobile devices that also have that technology installed. And this then enables very quick tracing of individuals, of course, with your consent to use the data to minimise the spread of COVID-19. Another example of this is ventilators and the monitoring, or remote monitoring or adjustment of parameters for ventilators. This then minimises the risk for healthcare workers needing to have direct exposure to patients with COVID-19 if they can monitor ventilator function remotely. Ethical considerations, of course. In times of limited supply, medical devices are allocated on the basis of clinical need and the ability to achieve the greatest chance of success. So emergency use authorisation or emergency exemption and expedited regulatory pathways ensure the ready supply of these products for healthcare workers and institutions to combat COVID-19.
Great, thank you, Michelle. Look, thank you both for your thoughts on this topic. I'd like now maybe to look at what questions others might have on this area. And we've got a first question from Lawrence here, which I think is probably for Madeline. Is IP an important consideration in China, and how enforceable is it?
I guess IP is important anywhere, and more recently the number of filings in China have greatly increased. Traditionally, it's been difficult to enforce rights in China, but I guess what appears to be happening is in China, people are filing more and more patent applications, and they're becoming more serious about it, which then will tend to, the courts will be more likely to strongly enforce those rights. So from what I'm seeing in my practice, many of my clients are looking more to China and putting those rights in place now, because you have to remember that with patents, for example, it's a 20-year term that you're looking at. So you're not looking for the immediate future, you're looking further down the track. So yes.
Great, thanks, Madeline. Another question that's coming from Jane, I think probably also for you, Madeline. If you're looking to get PPE onto the market quickly and you're concerned about others' IP, how long does looking for freedom to operate take?
So, I mean, depends on the extent to which your freedom to operate is going to cover, the scope of the freedom to operate analysis that you're going to have done. So for example, you could do a very high level freedom to operate to get a general sense of what's out there. It would be potentially quite a broad search. It will just pick up very obvious results, and it will give you a certain level of comfort. But that's going to depend on your budget and your risk appetite, really. If you want to do more in-depth search, you're going to produce a lot more results, which will then, it will take time and money to analyze those results and give you a certain level of comfort before you develop or launch your product. And clearly that would take a little bit longer to do. Under normal circumstances, we would say freedom to operate searches would take a couple of weeks to do, but at the same time, with anything, if something needs to be prioritized, they could be turned around in a number of days.
Brilliant, thanks. Michelle, I've got a question of my own actually. So this kind of current easing of the regulatory regime, is this likely to persist much beyond the present crisis?
No, there's some clear deadlines. So certainly in Australia, the deadline is January 2021. Of course, any deadline can be extended depending on the community need. And it's also important to consider that all other medical devices that aren't directly related to combating COVID-19 are following the regular regulatory pathways. There has also, of course, been wider implications for the delay of the introduction of the medical device regulations in the EU, and these are expected to come into force in May 2021. And in the meantime, to ensure the ready supply of medical devices, that the current medical device directives are still in place in the EU.
Thanks, Michelle. And perhaps just one more question, also from Jane. At what stage should companies start looking at which regulatory pathway they're looking to take? You know, is this at the start time when you've got a prototype stage, or once the final product's made? And is it something that's entirely driven by the product itself, or can a desire to go through a faster pathway affect product design?
Yeah, so it's certainly always really important to consider your regulatory pathway, your key markets in any part of device design, so that you can incorporate these considerations into the testing that's required to meet the appropriate standards for your device. Whether or not an expedited pathway can be considered really depends on the claims that the manufacturer intends to make for their device.
Great, thanks, Michelle. And another question from Andrew. Michelle, if a manufacturer does not have ISO 13485 and registers with AMGC, can they then manufacture without the need for ISO 13485 under the guidance of a manufacturer with it, and also with no need to provide a conformity assessment?
I think that would be a little bit tricky, Toby. I really think that you need to be able to demonstrate compliance to the relevant standards that you are applying as a manufacturer for your device. I think that could be problematic for a manufacturer, even if they're under the guidance of a manufacturer. It just doesn't allow you to be able to produce products for registration on the ARTG in Australia.
Okay, great. Probably just time for a couple more questions. Madeline, for you, from Tom, is it possible to extend the convention due date? And do we know if it was extended at the time of the Spanish flu?
I don't know. I don't know about the time.
Was that in the exams?
The Spanish. I don't think so. There are only certain deadlines that are extendable at the moment, and it depends as well on which patent office you're talking about. So I think that in a lot of cases, for example, renewal deadlines aren't being extended. In some cases, patents offices will give you an extension to meet deadlines, but you may need to show that you've been impacted by COVID-19. In other jurisdictions, they're just kind of putting a blanket extension or pushing out deadlines for a period of time. So it's something that you need to look at on a country by country basis and deadline by deadline basis.
Great, thanks. And just a last question for Michelle. So this is from John. Have the TGA released advice on the use of 3D printing?
They certainly have, Toby and John. Yes, you can find information on the TGA website that specifically relates to 3D printing of devices in the context of COVID-19.
Great. Thanks, Michelle. Look, I think we'll wrap things up there. Thank you both, Michelle and Madeleine. So perhaps just to sum up, we're in a time where regulatory authorities are responding to the pandemic by introducing relaxations such as these emergency use authorizations and expedited registration pathways. But at the same time, there are these constraints in some areas of exports such that we have a regulatory environment where it might be possible to move quickly, but it's still complex to navigate. On the IP side, there's still the need for patent protection in order to attract the investment to develop products, and ultimately in order to have control in deciding who and how they can be used. If you're pushing to launch a new product quickly to get it into sort of hospitals or onto the market, you still need to pay attention to your FTO, even in the current climate. And it sounds as though there's this need for a balanced approach in how you deal with your technology and how you license it in terms of getting return on investment at the same time as sort of making a meaningful contribution to the fight against the pandemic. So if participants have any other questions, please feel free to contact either of the speakers by email, and we'll pop up their email addresses on the screen now. And we'll leave them up for a few minutes at the end of the webinar. So please feel free to get in touch. But lastly, just to say thank you all for joining the webinar today, and goodbye.